good afternoon, and welcome back. This is another video in our series where we discuss everyday legal issues with TLR Law. TLR Law makes law accessible for the average Canadian. That includes drawing up wills and helping people settle estates. Check us out at tlrlaw.ca. Today we're talking about probate. One of the first steps in settling an estate is determining if probate is even needed. But before we answer that question, let's just figure out what probate is, why it's important. My name's Adam Dooley, and I'm your co-host along with Philippe Richer, principal lawyer and owner of TLR Law Office. Hi, Philippe. How are you?
Hi, Adam. Good. How are you?
Doing great. It's nice spring weather. We're now officially in spring. Hopefully be post-pandemic soon. So let's talk about probate. When you're talking with clients about estate planning, you're probably always asked about probate because it's a question that always comes up. But what is probate and why is it important?
Right. Probate is it's one of those words that we've all heard, but nobody really knows what it means. It's an archaic legal term that comes back from centuries and centuries ago of common law, and it's still used today. And it seems that only lawyers and courts know what probate actually means. Probating a will is essentially getting the stamp of approval of the court on the will that says essentially that the will on its face seems to be valid and that the person that you're dealing with is the executor. It doesn't make the executor official in the sense of gives them the power to start acting as executor. That's done just by the fact that the testator appointed an executor, and then as soon as the testator dies, the executor becomes the person who's in charge of the estate. Mm-hmm. But oftentimes the process of probate is required to give that extra little oomph, if you want to call it that way, that organizations like banks and the property registry and investment companies can rely on.
And it just makes it a little bit more official, right, for the executor?
Well, yeah. So it's not quite official. Imagine a scenario, if you will, where you are you're a bank teller, mm-hmm. and then somebody comes up to you with a document, essentially a Word document, because that's how we print our wills. And they say to you, "Look, I'm John Smith, and that's the name that's written on the will here as the executor. My uncle Barry died last week, and I'm here to take all of the money out of his account so I can distribute it in accordance with his will." If you're a bank teller, you've never met Barry before, you might say, "Okay, this looks like you printed this at home. How do I know this is official?"
Right.
So banks want a level of comfort that the person who's presenting themselves is in fact the person who's entitled to do this, and that somebody else won't come around at a later time saying, "Oh, wait a minute, that will is not valid. I have the right will here," and then banks could be liable if they give the money to the wrong person. So banks are hesitant to release the funds that are owned by the deceased to just anybody who comes with a document purporting the document to be a will. That's where the process of probate comes in.
That makes a ton of sense when you explain it that way. So our first question, we've got a slide I think that's coming up. How are letters of probate even created though? So do you as the lawyer make them? What's the process that an executor has to follow?
Right, so you have to go through an application process at court. You don't actually show up at court. You don't have to present yourself in a judge. You don't have to put your hand on a Bible or affirm to swear the truth. It's a paper process. So it's an application. The forms are available on the court website, actually. All the court forms are. Mm-hmm. And then you fill out the forms and in accordance with the rules, and there's certain things that you have to do, so it's very procedural in nature. Mm-hmm. And then you present that whole package, you send it to the court with the appropriate fees, and then a judge will take a look at it. And with that, you have to send the original will. The court will take a look at it if they're satisfied that the will meets the requirements of the Wills Act on its face, so the right amount of signatures, that it's dated properly, and it's a clear intention of the testator's wishes. Then they will essentially take a photocopy of the original will, They'll put a certificate on top of it. The certificate is essentially another Word document that just says, I, Justice so-and-so, hereby issue. And I can't really remember what the certificate says. And then they put their stamp on it. And then the stamp, and then that package with the will attached and the letter and the judge's signature and the stamp all form one package, and that's the letters of probate.
And does that come back to you as the executor by mail? Do you have to pick it up at the courthouse?
Yeah, it'll come back usually. So if we act for an executor, it'll come back to us, to our office, and then we'll call the executor. If you do it on your own, which you can, I wouldn't recommend it, but you can. I imagine it would get sent to your home, or you would get notification to come and pick it up at the courthouse. I'm not entirely sure.
Right. Now, let's dive into why you don't recommend it, because there's lots of things that can go wrong in that process, right? You as a lawyer who does this all the time, you know the pitfalls that you're probably going to encounter. But talk to us a little bit about that.
Yeah, so the court process is very procedural in nature. And if you've ever watched movies where they talk about, in kind of a caricature way, the DMV, the Department of Motor Vehicles, there's always huge lineups, and that the people at the counter are not very helpful, and you need this form. And if you don't have this form, they can't help you. And then you got to go to a different counter to get the other form filled out so you can come back to and you wait in line, all that. So take that and put it on steroids, and you have the court process.
We have all stood in those lines and wished for them to end quickly.
Yeah. So you stand forever, and you actually do stand in line at the courthouse because there's a counter there. You have to take a number, and you have to wait your turn. And then when you get up there, they're not in the customer service business, so they're not going to explain to you what you've done wrong. In fact, they'll say, "Well, I can't tell you anything about this because I'm not a lawyer. You need to get legal advice if you want any advice on how to fill this out." So you fill it out and you send it in, and then it'll get rejected. And I've had a case once where the same document was rejected 3 times. So what would happen is they would go down the application, find the first error, reject it, tell you the reason why they rejected it. Then you sent back to you. We'd fix the problem. We'd pay the $5 rejection fee. We filed it again. Then they'd go down further the document, find the second error, reject it at that point, pay the $5 fee, and we went through that process 3 times on the same document. So it's not even like they go through the entire document. Oftentimes they're not even helpful in that sense to go through the entire document. They'll just, as soon as they can reject it, they'll reject it, and they send it back to you.
It sounds like it could take weeks then. This could really slow down the process a lot.
And it took us weeks, and we do this all the time. One time you'll put something in once and you'll get it through, and another time you'll do something similar and you won't get it through, and it's just hard to determine exactly what that process is. We do enough of these that we get most of them through without any problems. We get rejection notices once in a while. It happens. I suspect all lawyers have that happen.
Right.
But it's a very procedural process. There's very little information about how to go about doing it, and we end up just knowing through experience because we do these all the time, and that's how we end up knowing how to do it and how to do it best to get it through in a timely fashion. I mean, as it is, it's a process that can take anywhere from 3 to 6 weeks, depending how busy the courts are, once you have all your information. So even getting to there can take a while. But once you have all your information and the documents ready and you submit it, that process at the courthouse can take anywhere from 3 to 6 weeks.
And the whole process of settling the estate is really depending on this major step being crossed, right? You can't really do much until this is done.
No. As I said earlier, the Wills Act of Manitoba is the law on wills. And it says a testator, if they appoint an executor, that executor becomes the person responsible for the estate the moment the executor dies. The problem is that getting money out of banks, getting money out of investment companies, getting titles of property transferred at the property registry, all of those things require letters of probate because all of those organizations want some kind of security that protects them. Because once they get letters of probate, they're no longer responsible for the money. They can give it to the executor, and they can say, I'm satisfied. And then anybody who challenges the will or who wants to challenge the will at a later date, the banks are not liable to them because they are now shielded because they have a copy of the letters of probate that they've requested. So all of those organizations will want to have that protection before they release the funds. So while in theory, the executor has the power to do all the things that they're supposed to do under the will on the death of the deceased, in practice, really not much gets done until you have those letters of probate. And that's when you can really start getting, accumulate or recuperating all of the funds, putting them all in one bank account for the estate of, and then you can do your distributions.
That makes a lot of sense.
From that bank.
Well, let's talk about what's included in probate. So this is question number 2. What is there? Like what assets are covered by probate?
Because probate law, if you want to think of it that way, is a provincial jurisdiction. So the courts in Manitoba require a deceased to probate their assets in Manitoba. So if somebody dies in Manitoba, they lived here all their life and all their assets in Manitoba, not a problem. You apply here and then you just list all the assets, so all your real estate, house, cottage, revenue properties, whatever you have, bank accounts, how much is in the bank account on the date of death, investments, what were they worth on the date of death, and so on and so forth. Car, personal assets, your furniture, we have to put a value on all of that. And then that goes in with the request for probate.
Right.
If you lived outside of Manitoba, but you have property in Manitoba, then you need to probate in Manitoba still, even though the deceased lived somewhere else. Now, if that deceased lived somewhere else and owned property elsewhere, and also owned property in Manitoba, they have to apply for probate in the jurisdiction in which they died first. And then we do what we call a resealing of the probate documents that were probated in that jurisdiction. So, for example, somebody dies in BC, they have a condo in BC, and they have a family cottage here in Manitoba. They would probate in British Columbia. Then we would get the letters of probate here, and we would reseal that document. Reseal is really just taking the Manitoba seal, the judge seal that they put on the letters of probate, and resealing over top of or next to the seal that was put on by the BC courts. So that's why we say resealing. It's not resealing in the, closing it up again.
So one common situation here in Manitoba, there's lots of people who have cottages in northwestern Ontario, so I guess they would need probate in both provinces, right?
Correct.
Right. Okay, I think I'm a quick study. I'm learning how to do it, but I still need your help.
There you go. You can open up your own law office after.
I'll leave that to you. So I have my letters of probate now. What do I do with them? I'm the executor. I've gone through this process. What do I do with them?
So once you have your letters of probate, that's when the action really starts. You could start doing all the things you're supposed to do. So you would, at that point, if you have any property, it's probably the best time to list it for sale, because you can't. I mean, you could list it before you get the letters of probate, but you can't transfer title without the letters of probate. So it's a good idea to make sure you're well into the process of applying for probate before you actually put the property on the market. And then depending when possession date is, but you can go through that, put the properties up for sale, negotiate the offers, sign the documents as executor in order to transfer title out of the deceased's name into the estate and then into the buyer's name. You can contact all of the investment companies. So if there's money in the RSPs, for example, you can contact them, tell them that you want to liquidate, get all the money out. You put it in an estate account, the estate of the deceased. You would get all the bank accounts. You would empty those. You'd assemble all of the cash in one bank account. If there's any assets in the house that you wanted to distribute in specie, that's fancy language just to say giving the actual items instead of giving money, you can start dividing those assets. Oftentimes there will be sentimental value items, so those things you don't need to wait for letters of probate for that. You can start handing those out beforehand.
Yeah, an old quilt or or a picture
Yeah,
that grandma painted or
paintings,
something. Yeah.
jewelry, meaningful things. So hopefully the deceased, made a list of the things, the meaningful things that they want distributed and who's supposed to get them. If not, then hopefully the family gets along enough at that point, because it's hard when you're grieving, to be able to divide the assets without causing any problems within the family.
That makes sense. So, question the third question we have a slide for. If I'm an executor and I'm working overseas, and I don't know how often this comes up, but we thought it would be worth exploring. Can you still apply for probate? Like, are there any different rules
Yeah.
if you're living somewhere else than Manitoba?
Yeah, so if you live in Canada, it's not a problem. It's not that much of an inconvenience if you're not in Winnipeg. You can meet a lawyer in another jurisdiction just to sign the Manitoba documents, and they just send it back to us. However, if you live outside of the country, the courts in the country no longer have jurisdiction over you, so they require a lot more security. So a commercial bond might be necessary. So it is a little trickier if you're a foreign executor. And there's also some tax rules that can come into play, because the executor is the representative of the estate. And if the executor is a non-resident and the non-resident sells assets in Manitoba like real estate, then non-resident tax may apply. And that's very tricky. So I would absolutely recommend that you speak with the lawyer and an accountant about that, because you can get yourself in a lot of trouble if you're not aware of that. It's
Right.
a 25% of the total value of the property has to be withheld. It has to be remitted to Revenue Canada within a very short period of time. And if you don't do that, then there's a bunch of penalties. So it's important to make sure that those things line up properly, and you look after that. So there are some traps for foreign executors that you have to be aware of, but it's possible. We've done one recently where we had a foreign executor.
Well, I imagine it's going to become more common. There's such a huge immigrant population that's growing every year in Manitoba, so I imagine this is something you'll encounter more. So
Right.
let's explore another situation. What if years later, so you were the executor, or I was the executor, we settled the estate, and then years later we discovered new assets that should have been included in probate. What do you do to resolve that mess?
Yeah, well, it's not that much of a problem. You would hopefully you keep. Well, there's two aspects to that. But if you discover assets that were there, and that it's years later and they weren't included in the application, then you would simply file an amended application. And we call it the inventory. So an amended inventory application, then sending it to the court saying, look, this is the file. We discovered this asset. This is what the value is worth. Now, I mean, we still have to do that. This was a bigger deal when probate fees applied. In Manitoba, probate fees no longer apply. That's something fairly recent. Mm-hmm. At the time probate fees applied, they applied on the value of the estate. So when you found extra assets and you probated, you would have to also pay the probate fee to the court at that point for that. There's no more probate fees. The law that you still have to do it exists, so you still actually have to go through the process of doing it, but there are no fees attached to it. So it's really not that big of a deal anymore for the estate to do that. There's also the situation where where you apply for probate and you think the estate is all taken care of, and years and years and years later, you get a call saying that this person was entitled to receive money from a lost relative, or maybe there was a lawsuit and there was some money available through the lawsuit. So it's important not to, if you are an executor, not to throw away your letters of probate once you think that it's all done, because it's possible that years and years later you'll be required to get those again. Now, if you don't have them, you can still get a copy from the court if you have to, but ideally you would keep it. They don't take up a lot of room, so it's a good idea to hang on to those.
Yeah, put them in
a
deposit box or a fireproof safe or something.
Yeah, keep it with your personal documents, yeah.
So every time we talk about wills and estates, it just seems like there's so many little things that if you're a lawyer and that you're doing this all the time, you know about. But if you're not, if this is your first rodeo as an executor, you're really learning an awful lot very, very quickly. So, going back to our original discussion, it seems to me it just makes so much sense to hire somebody who's done this before. It's probably going to be way faster, and in the end, probably save everyone a lot of grief and problems.
Yeah, there's also the fact that typically an executor is somebody who's close to the family, right? Parents will name each other as executors, and then they'll name their children as executors. So not only are you dealing with the legal system that's not user friendly, but you're also grieving the loss of your parent or your uncle or your cousin or your brother or your sister. And when you're going through all of that, butting up against the frustrations of bureaucracy and unclear instructions can be very frustrating and demoralizing. So lawyers, we do a lot of the heavy lifting when it comes to this stuff. We guide the executors through the process, and it just makes a lot of sense. And then we can become kind of the bad guys, right? Because the process can take a while. People may want to get their portion of their inheritance quickly, and then they're phoning the executor, say, how come I haven't received this yet? Then the executor can turn around and just say, well, it's in the hands of the lawyer, and the lawyer's handling it right now. And we often field those calls from beneficiaries, and we explain to them, we represent the estate, we're doing the work that we're supposed to do, everything's going in accordance with plan, and we're sorry that it's not getting to you fast enough, but that really isn't our concern. Our concern is to make sure that the executor and the estate are looked after. Yeah, now, it doesn't mean that we don't care, it doesn't mean that we drag our feet. It just means that, we've got our eyes focused on the ball here, which is the executor and their role and responsibilities. The beneficiaries will get what they're supposed to get in due course.
And there's so much responsibility involved with being an executor and so many rules to follow. It seems to me to make complete sense to hire someone who is well versed in all of that. So that's my pitch. I think it just makes sense. So thank you, Philippe. Thanks for helping us review probate. It is a question that comes up quite often whenever people are talking about settling estates and wills. That's it for today. We're going to come back next month with a new episode. Until then, visit us at tlrlaw.ca. TLR Law now has 3 locations in Winnipeg. The head office at Provencher and Taché. There's another office at Pembina and Markham, and the newest office at Sargent and Wall. You can follow us on Facebook and Instagram. Just look for TLR Law. Thanks again. Have a good day.